Today, just doing a little research. My job, luckily, thankfully, allows me to do a lot of research, and because that is most of my job. My job is a consultant, business, financial, and of course now with YouTube, as many of you know, my persona, One Adam 20, is a role play voiceover cop in LSPDFR. And any of you who do the same thing I and so many others do likely have heard about the nice individuals at Take Two, and I use the term very loosely and very sarcastically, if you couldn't get that. Lately, they've decided that modding their game through the use of OpenIV software is illegal. Well, this doesn't sit right with me. Not at all. Because, for instance, if you owe money to a credit card company or to a contractor, or if you're just being called by a scammer, technically speaking, they break the law when they threaten you with any legal ramifications. You don't pay us now, you're going to go to jail. That right there, even if it was a legitimate collections call, means they just violated the law and it invalidates everything they're saying to you. Moreover, you could theoretically sue them, but we're not talking about debt collection, and as far as that goes, we're talking verbiage. And I'm getting this line from OpenIV, basically in their cease and desist letter. They said that, and I will show you. OpenIV was discontinued due to Take-Two's interactive request. On June 5th, 2017, we had received an official letter from Take-Two that declares modding of Take-Two games as an illegal activity and demands from us to discontinue this project. A cease and desist letter to demand to discontinue this activity because it is illegal. Well, I don't know where Take-Two operates. I don't know where Take-Two wants to be from, and what laws or power to create or make laws it thinks it has. Laws can only be made in the United States in one of three locations. The executive branch can draft an executive order. The Congress and the Senate, with presidential approval, or with enough votes to override a veto, can make law. The Supreme Court, or any court throughout the land from border to border, can actually make law through what's called case law. And this is where we're at now. Through my research, and it took me exactly 30 seconds to find this, I found an old court case regarding first sale doctrine rulings. Okay? Basically, what this rule states, the first sale doctrine, basically means if I go to the store and I buy a new cordless phone, 2 years later, I'm going to get a new cordless phone. I don't need a second cordless phone, but it still works fine. And I go through my garage and I have a bunch of shit. But it's good shit and it's not broken. I can have a yard sale. I can sell everything that I didn't make, that I didn't produce, I don't own a copyright to, I don't own a patent on. So if I have CDs that I bought 10 years ago and I want to sell them for $1 a CD, or a cordless phone, a TV, whatever, I don't own the copyright or patent. According to Take-Two Interactive's directive, they would say, no, you can't sell it. Well, Take-Two Interactive, I'm sorry, but you would be wrong. The first sale doctrine says, because I bought it, I own it. And I have the right to get rid of that property in any way I want. Or I have the right to use said property because I bought it in any which way I want. You no longer have jurisdiction over that property, whether it's real property or intellectual property, which GTA technically would be both. The issue of first sale doctrine has been many times challenged. Most notably, as you're seeing there, March 19th, 2013. There's a 6-3 decision in the Supreme Court that upheld its previous rulings on this first sale doctrine, which allows the owner of a lawfully made copy of a copyrighted work, and it also includes patented work, to freely sell it. Also applies to the resales of copies lawfully made abroad. The reason that was added was because there was a case that challenged it that had a college student importing his books from his native Thailand, purchasing them, and then reselling them here. The Supreme Court upheld that, saying first sale doctrine. He owned it, his right to get rid of. So, the copyright, and as part of this, under the decision of Kurt Sang versus John Wiley and Sons Incorporated, on case number 11697, March 19, 2013, held that a copyright's owner right to prohibit importation of copies is trumped by the first sale doctrine. Decision also benefits individuals and businesses such as online retailers and gray market importers. Basically, first sale doctrine supports OpenIV's modifications that it allows its users to do, and overrides their ability to prohibit any changes to the game. Assumingly, anyone out there playing the game, I'm making some basic assumptions. We all purchased the game legally, paid our $59.99 or whatever it cost when you bought the game from Steam or from Rockstar or Take-Two directly. As soon as that transaction was completed, first sale doctrine goes into play. As long as we are not operating the game in such a way to hurt Take-Two Interactive or Rockstar, first sale doctrine applies fully. It's our game. We have the right to play it. We have the right to mod it. We have the right to resell it if we find that we no longer want the game. And Take-Two Interactive and Rockstar are helpless under Kurt Sang versus John Wiley and Sons Incorporated, case number 11697, March 19, 2013. 2013, a 6-3 decision that upheld the first sale doctrine. That is where they get hung, this is where they are hanging, and this is why they are wrong. More than that, this is why they also broke the law when they said it is illegal for you to do so. They're not a court. They're not the legislature. They're nothing but a corporation with no more rights and privileges than you or I have. They may want to use spooky language, to quote George Carlin. We had received an official letter from Take-Two that declares modding of Take-Two games illegal. Spooky language. Ooga booga. Ooga booga. We're strongly recommended to uninstall OpenIV to avoid possible legal issues. So now, through OpenIV, Take-Two is threatening everyone on unlawful ground. If you want to try to enforce something, Take-Two, you better take a second look. Do like your name says. Take a second look. Because the Supreme Court's already ruled, and the Supreme Court made the law that you're trying to act like you made. You didn't make shit. You made a great game. The people who love the game made it even better. Under their right of first sale doctrine. That's all I have to say today. I don't like bullies. Never have, never will. And the older I get, the less I like bullies. And companies who think they're all powerful and mighty, and their word is law, and their shit don't stink. So I will ask, go ahead and share this on social media. Go ahead and share it everywhere. It's already going up to Twitter. It's already going to YouTube. It's already going to. I've already gone live on Twitch. And yeah, it's already a bunch of different places. It's going to be on Facebook. It's going to be on Twitch. It's going to be on Twitter, YouTube. But share it amongst yourself. Under this first sale doctrine, Take-Two does not have a leg to stand on. They say they make the law. I'm calling bullshit. I'm calling bullshit. They make nothing except a game. Okay, like I said, do me a favor, share this amongst your circles, get the word out. And let's continue to make some, have some fun maintaining the law in LSPDFR. 1AM20 dispatch. Show me code 4, 10.7, and 1042.